How exactly is a DUI defined under Florida state law? Every state's definition of a DUI is different. You may hear the same offense called a DUI, a DWI, or an OWI, but they're all the same thing. Just like the names differ, however, the actual statutory definition differs from state to state. For example, in some states you may only be charged if you're driving on a public highway. Not so in Florida. In the Sunshine State, a DUI can occur anywhere in the state. There are two ways for the state to prove a DUI in the state of Florida. The first is by showing that a person was driving with a breath or blood alcohol concentration above 0.08. If a person was above that level, then they're considered guilty of DUI regardless of whether they were actually impaired. The law presumes impairment above 0.08. The second way to prove a DUI case is by showing that a person met the statutory definition of DUI, which means that they were, quote, under the influence of alcohol to the extent that their normal faculties were impaired, unquote. This is sometimes referred to as a common law DUI. In a common law DUI case, based on all available evidence, including video footage, audio recordings, and any admissions made, jurors will decide whether or not someone met that definition of DUI. This means that even in the absence of a valid breath test, showing a breath alcohol concentration above 0.08, the state can try to prove beyond a reasonable doubt that the defendant was under the influence of alcohol. For example, if a person admitted to having consumed a whole 12-pack of beer, was slurring their words and stumbling around, then they might be proved guilty of DUI beyond a reasonable doubt, regardless of whether they passed the field sobriety tests.
Tom Hudson is widely respected for his training and knowledge of the field, as well as his decades of trial experience. The Hudson Law Office has represented thousands of citizens accused of crimes for over 30 years.